In Zoom?
Yeah.
Okay. Court does call the case of Arbor Woods versus Tanya Anthony.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
And
She's also.
Good morning.
oh, she's on the phone.
Yeah.
Okay. Say your name
Can you
again,
hear me?
please.
At first glance, this looks like a routine civil docket, but listen closely. Behind the polite greetings and procedural language is a long-running dispute, real money on the line, and a judge clearly trying to balance fairness with frustration. This is where small delays turn into big legal consequences.
Tanya,
Yes, ma'am.
Anthony.
Okay. Is Charmaine Napier there?
No, he's at work.
He's at work. Okay. Very good. All right. My understanding is there's an agreement on this.
There is indeed, Your Honor, and I'm also happy to report to the court that Ms. Anthony did drop off the $900 payment referenced in the agreement, so this matter is fully resolved. The account is paid in full.
It's paid in full. Okay. So she's paid everything and I'm signing this, but everything's all done.
Correct.
Is that correct, Miss Anthony?
That's correct.
Okay. What I'm going to do is I'm going to enter this conditional order of dismissal. You do have 3 business days to think about it since I'm signing this. And if you believe that there's some legal reason, some confusion, or some right you didn't assert, you'd have to file a motion with the court within that time frame for the court to set it aside. Do you understand that, ma'am?
Yes.
Okay, I don't expect to hear from you, but if I do, you've got that time, okay?
Okay, thank you.
All right, thank you. And you take care of yourself.
You
Ms.
too.
Dornish, is that it for you?
That is it for me today, Your Honor. Thank you.
Wonderful. All right, take care.
Take care. See you Friday. Bye-bye.
Yes, ma'am. Who is this? Jerome versus Cassidy.
Extra time if you get.
Jay. Well, hold on. Do I have everybody?
Sir Cassidy is in Zoom.
Got it. I got counsel for the parties, Jerome's. I counsel for Jerome's and for the Cassidys.
Yes,
Right.
Your Honor, I think we're appearing on behalf of the Jerome's plaintiffs in this case.
Yes. No,
Oh, okay.
really? Boy, I haven't followed that along after the last 30 hearings. I get that.
Okay.
Okay.
I'm new.
Yes, I do. Well, and that's what I'm saying. I'm said that's not Lloyd, so I don't know. But I was informed you're representing.
Eric and Paula Cassidy. That's
So
correct.
you're representing both.
I am representing.
Okay, good. So that has all come together.
I don't have anybody for Cambridge.
The money was paid and one case ended, but another long civil fight stalled again as the judge granted yet another delay.
Just a bundle of sunshine.
A ball.
A ball of sunshine. Okay, I don't have anybody for Cambridge. And trying to recall, is Miss Tope gonna be here?
I'm checking now, but I don't believe I have any communication from this. And she's normally pretty good about communicating.
It was nice of you to say it that way. So do any of you know with reference to Miss Tope?
I have not heard from her regarding this particular motion, Your Honor. We did serve her with the motion, and she's been otherwise in communication with me on other matters as recently as yesterday.
I haven't heard from Ms. Joe.
All right. So is everybody prepared to go ahead with your motion then?
Yes, Your Honor.
Okay, go ahead.
Okay. Thank you, Your Honor. The motion before the court is to the court to obtain concurrent jurisdiction over the monetary claim which exceeds the court's limit at $25,000, or in the alternative that the damage claim for unpaid rent be removed to circuit court. At the time of filing of the motion, it was all parties And it was all parties through counsel's preference that this court keep jurisdiction to hear the monetary claim, given the long history of this case and the court's intimate familiarity with what's going on and how we got here. And it was thought amongst counsel that it was judicially prudent to keep it here instead of starting over in circuit court with a new judge. And so and the court had expressed in the past its willingness or openness to doing so. So I filed a motion to bring that to a head so we can move on. The parties have spent an inordinate amount of time trying to settle this case. It's not happened, and we're ready to move forward with ultimately what is a rent issue from landlord's perspective. So we'd like the court to obtain jurisdiction if the court is willing, and also to move forward with trial. And I understand new counsel wants to clean up some pleadings, which we would be amenable to as well.
You have a position on this?
Thank you, Your Honor. Go from here, wherever.
Either.
First, I will say I appeared yesterday on behalf of the Cassidys.
Yes.
I'm relatively new to the case. As I see it from the docket, Cassidys have not been able to file a response to this motion. I also note that Ms. Job is not here. Frankly, I think it would be helpful if we could continue this motion to just next week. I can file something by the end.
Okay. So you need time to talk it through with your clients, figure out if that strategically is what you may want to do, and then do.
That would be very helpful.
Okay.
And while I'm making that ask, it'd be helpful if we could also amend. I know that the clients had filed a request to amend or leave so that they could file their answer to the last amended complaint. It would be helpful if I could also do that by the end of the week.
Well, let's do this. Since what I'm going to do is I'm going to adjourn this. I don't think, yes, this has been going on for a long time, but I'm going to adjourn everything, but I'm going to give you time to get to figure out exactly what you want to do. It would be nice if it were a case one could step into and just decide. I think counsel for the plaintiff is correct. I think that everybody was reported to me, got together and decided, yes, we want to kind of go along this path, and they were trying to sure things up. But in fairness, now that the Cassidys have one attorney, because I think, if I'm recalling correctly, I think throughout these proceedings, they've had separate attorneys for a number of different reasons. I'm going to give you an opportunity to do that and to clean up the pleadings. Have the two of you communicated with each other?
We just did this morning.
Okay, so extensive conversation.
So
no, that's okay. I think counsel for the plaintiff can give you certainly some background as to where it is, and then you could factor that in as to what you will do. All right. This is the second time I think we have actually technically been here on this motion, and I'd like to resolve it, but I also just want to be fair. So
I appreciate that, Your Honor.
You were going to say something else?
Yes, Your Honor, I understand, fellow counsel just arrived and his requests from his perspective are absolutely reasonable. But Your Honor, it's becoming exceedingly frustrating for the plaintiffs, the defendants to now be on their fourth counsel, which has led to a number of delays, late filings. And you're right, this is the second time we've been here on this motion, and we are very anxious to proceed and not continue to spend time and money while the defendants figure it out. And the prior adjournment was on December 2nd.
That's correct.
And it is now January 6th, and the new appearance from the new attorney was yesterday. There was plenty of time for the Cassidys to do the things that they needed to do. I want to place an objection on the record, and if we're going to get the additional time to have that be the end of the time.
Yeah, it will be. And let me just say this, and I appreciate what you're saying in your objections noted, but what the court is inclined to do, because we had all talked with the counsel, is do one of two things. If we could get jurisdiction over the whole case through order, then we could do that. But also, the court's understanding is I can hear the claims, award the judgment, and then somehow there's a process by which it is then certified in circuit court. So if it exceeded my jurisdiction, you just take that judgment and it's just signed off on by a circuit court judge. There's a process by which it can happen, and on a landlord-tenant matter, particularly. So that is the court's inclination. And I say that not ruling at this time, but I say that for your benefit so that you understand as you have your discussions. That's where I was going to head.
And I appreciate that, Your Honor.
Okay.
I will also note, I know that this was December 2nd. I know that there's been a statement that the Cassidys had a lot of time. I don't want to necessarily put it on the record. I'm happy to approach and
there are issues with Miss Cassidy. Is that what you're? Yes. And I think we're all aware of that. And so I understand that. I mean, in a lot of ways, it was an odd circumstance because there were issues with an attorney who's not here today. We had to get through all of that. Then the Cassidys have two attorneys. That becomes the issue. And then one attorney, and I don't know the reason, I'm not saying it's bad or anything like that, for Mr. Cassidy leaves, but then another attorney appears, kind of, Mr. Lloyd. But Miss Cassidy, then that issue regarding her counsel had to be solved, and I'm not sure how that, I know what I did, but I don't know how that got resolved within the university. So a lot went on. So, and I appreciate it. I understand the time frame. I understand all of that. And this file just keeps getting bigger, and I don't have files this big. So, all right, so we'll do it. So how much, you were saying a week, are you going to be able to?
I mean, I don't want to delay this, inordinately. A week.
They're so cute when they're young. No.
Thank you.
No. I can do this tomorrow. Anyway, no, but if you have to, you can, right?
If it helps, Your Honor, I'm not able to be back in work a week from today, but I could do it 2 weeks from today on the 20th.
Do I have that day?
You do, you actually don't have.
I don't have 1 week, but I have 2.
2 weeks on the 20th.
Okay. Oh no.
Yeah.
We have our one and you're not here.
Yes.
It's sounds like a bad day for me, but that's okay. Well, do I have the 27th? No. I do.
New lawyers stepped in, old issues remained, and the court pushed the decision weeks down the road once more.
Okay, so that you guys don't get behind somebody and I have no idea what's going to happen that day. And that Ann won't be here to calm me down if it gets bad. Will the 27th work for you?
Yes, sir.
Yes, sir.
Well, okay. Let's do it that way. So I will adjourn the motion out by the 27th. You're going to get all of your pleadings and everything in order. Why don't you do it in case there needs to be any type of response? Could you do that in, say, 2 weeks?
Yes, sir.
Okay. So get all of that done in 2 weeks, so that way if plaintiff needs to respond, they can.
Perfect.
All right? Fair enough?
So hearing is adjourned until the 27th at 9 a.m.
Yes.
And then any revised pleadings would be due on the 20th.
Yes.
Perfect.
Okay, thank you.
And since you're the one causing the problem, can you prepare an order to that effect?
Absolutely.
Since you can do it. All right, fantastic. All right, thank you. Thank you, folks.
And that's the truth of civil court. Even when money gets paid and agreements are signed, the fight doesn't always end. New lawyers, old problems, and repeated delays can stretch one case for years. The law moves carefully, but patience runs out fast. Was this adjournment fair, or just another delay? Let me know your take.